Well, welcome to the Ahern video podcast. This is the due diligence process part 2. Last week I discussed and I touched on some of the aspects of going through a due diligence. I talked about the letter of intent, which is a non-binding contract. I discussed certain things that you as a seller have the right to ask the buyer before you proceed. I indicated that the due diligence process is a very tough mental process. It's emotionally draining. And at the same time, I also touched on the fact that just because you receive a letter of intent doesn't mean you're going to cross the finish line. So don't take your eye off, quote, the ball. Today I want to talk about how to use your advisors. Obviously, you should have an accountant involved to give you the tax advice, and you should have an attorney involved. But both of these individuals are to provide you input. They're not to negotiate, they're not to get in the way, and they're not to run up the meter. Now, there's many good law firms or many good accounting firms, but I can tell you that if you don't take control of the situation, you can run up a substantial amount of bills and never cross the finish line. So the first thing you have to realize is that 90% of the transactions today in the trucking industry are asset sales. I don't care what your accountant says about you need a stock sale. It's not going to happen. But what you have to do is you start with a pool of money and you start working backwards. Once you get the letter of intent, once you've agreed to a range of values, then as you go through the due diligence process, you can talk about structures. You can talk about maybe putting more into a non-compete agreement instead of in goodwill. Now realize this, a non-compete agreement isn't over and above the purchase price of the business. It's included in the purchase price. Assuming that you're going through the due diligence process, at some point in time you're going to get a contract to purchase. It's a purchase agreement, and in the purchase agreement it's going to have specific parameters, and that's where your attorney gets involved. We have to be very careful, because initially what will happen is the buyer will prepare a contract, he'll send it to you, you forward it to your attorney. Your attorney will redline the things he doesn't like, he'll send it back to the buyer's attorney. The buyer's attorney will redline what he doesn't like, he'll sell it back to and you see what happens? It's going back and forth. Well, all the time the meters are running. So rule number 1, once the initial purchase contract is drafted, and once your attorney as the seller has reviewed it and there's concerns, you pick up the phone and you talk to the buyer's attorney, and you as a seller have the right to talk to the buyer and see if certain things that concern you can be changed or can be agreed upon. But don't keep sending it back and forth. It does 2 things. It runs up your cost, and 2, it drags on the process. You have to set time frames, because if you don't, attorneys and accountants are very busy, and what happens? You never reach the timetable. Well, if you never reach the timetable, then how are you going to cross the finish line? Once you've gone through that process, once a purchase agreement, there's still things you have to be aware of. If you're a trucking company, you have to know what the actual value of the equipment is, and that's something that should have been agreed to in the prior to or during the due diligence and letter of intent process. Depending on the age of the equipment, the miles on the equipment, etc., it'll either be orderly liquidation or fair market value. In some specific cases, you may be upside down on the equipment. And if you're upside down on the equipment, then it presents an additional problem. But there's ways to get around those issues. Next week I'm going to talk about exactly what you have to do, what process you have to go through, because 9 out of 10 times closing is held up due to the fact that the schedules of the equipment with the payoffs as of a specific date were not provided to the bank in a timely manner. Therefore, the buyer's bank requires certain lien releases on all titles. And so it's pushback closing, sometimes pushback closing for 3 weeks. What does that do? It adds to the emotional aspect. It adds to the anxiousness. And this is a process that's overwhelming. This is a process that's very emotional. This is a process that when you get towards the end, I'm going to tell you what else you're going to go through, but this is a process that's necessary. So rule number 2 is to control your internal cost with your consultants or your advisors. Set time frames. Don't let them run up the meter. Tell them exactly what they're expected, when they're expected to get it back to you. Particularly for the lawyers, don't redline and send back to the buyer. Let the buyer redline, send back to the seller's attorney. Seller's attorney sends it back to the buyer, because you're wasting time and you're wasting money. You should be able to go through this process, depending on your size, no more than 2 or 3 times, have a contract to purchase agreed to. In closing, I must stress again, keep your eye on your business. Don't let key employees know what's going on unless absolutely necessary if they're part of the process. But any time you let an employee know, 9 out of 10 times everybody knows. Until next time, thank you for attending the podcast.